regular meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force, brought to order at 4 p.m. on August 9th, 2011. Are we okay?
Yes.
Mr. Eston, would you call the roll, please?
Yes, Madam Chair. Member Snyder? Snyder absent. Member Nee?
Here.
Nee present. Member Washburn?
Here.
Washburn present. Member Wolf?
Here.
Wolf present. Member Johnson?
Here.
Johnson present. And Chair, we have 4. We have a quorum.
Okay. Would you call the next item on the agenda, please?
The first item is approval of March 8, 2011 regular meeting minutes.
Madam Chair, I
yes,
move,
Member Nee?
I move to continue these minutes. I find them incomplete. For instance, in item number 2 on packet page 5, 4 and 5 actually, it says, heard complainant Dorian Maxwell and respondent Cynthia Chambers provided their status reports. I think it would be more helpful to us and to members of the public if a brief summary of what they actually said was provided. In other words, Member Maxwell might have said that the compliance, the order of the termination was not met. I still have not received my documents. Cynthia Chambers might have said, we have provided all responsive documents that we have. This, to me, this is incomplete. In item number 3, there is no indication of whether either party in interest spoke. So I move to, I should have waited for a second before discussing my motion, but anyway.
I'll second it.
Okay. Again, I just believe that the minutes are incomplete, and they could be more complete without too much extra effort.
Right. I noticed the same thing. In particular, a problem I had, again, it was item number 2, top of page 5. There was public comment apparently on your motion, seconded by Member Wolf, to send this back to the task force with the recommendation that be forwarded to EOT, and that members of the public, Thomas Piccirillo and Alan Brisbane, spoke in favor of it, and I doubt very much that they spoke in favor of that. They were probably suggesting we do something else, so we need more information about what they said, because we then changed the motion to something much more severe. So I agree that we need more information here. Is there any public comment on these minutes?
Good afternoon. Yes, I would, Thomas Piccirillo. Here you go. Okay. Is it better? Yeah, I would concur with the motion. The minutes are not in compliance with your sunshine ordinance. Thank you.
Thank you. Any additional comments from members of the public? Seeing none, then the matters back with the committee. Member Johnson?
No. I don't know if I will say that it again, it kind of comes up when we're trying to do the referrals and the orders of determination. There's some dissension between me and the attorneys as to different things that are going on. So it's a little bit hard when it doesn't have like that kind of detail to go to the right spot. So.
Right, and I would say that it's it's very hard for the members of the task force to understand our reasoning for referring something back to the task force, and we spend time trying to reconstruct our reasoning, which wouldn't be necessary if we had more complete minutes. So. Anything else? Mr. Russell, would you call them?
Yes, Madam Chair. Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
I,
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes. The motion passes.
Would you call the next item on the agenda?
Item number 2 is approval of April 12, 2011 regular meeting minutes.
Move to approve.
Second.
Member Snyder.
I have a question or a point. Has there been any discussion about the location of the meeting and whether our posting requirements under the Building Act were met? Because when did we post that the room number was not going to be 406?
Mr. Russell.
Mr. Russell?
Madam Chair, the 406 was posted, I believe, Friday morning.
And what about, so this is 276,
It was done 5 minutes, 10 minutes before.
this meeting?
Yes.
Yeah, I don't, I'm not, the Brown Act is not an area of expertise of mine, but the requirement is that the meeting has to be 72 hours in advance. The time and place of the meeting have to be posted, and it would stand to
But
reason.
the time and the place has been posted, and then an alternate location has been notated. It's in the same building. It's not like it's across town, which would be, I think, would be untenable. But I think as long as it's if somebody goes there and there's actually a sign posted that it's clear that this is where the location is, because the room that we're in there is still being used by the previous group.
Right. So the correction, yeah.
The issue of moving down here was because 408, we would have only had an hour, and then we would have had to move anyway, or shut down the meeting.
Yeah.
So unfortunately, there's some scheduling issues in the building
Can any of y'all
today.
remember if we've done this before, had to do this before, where we changed the room number at the last minute?
Yeah, oh yeah, many
Happens all
times
the
over
time.
the years, I'm sure,
The address wasn't where it was posted to.
Yeah.
I'm sure.
Posted at 276, it's not even.
we were just talking about it, that's why we was laughing. Just
Member
having a
Yee-
conversation
Member Yee's has
about
been here
whether it was posted.
for some
Okay,
time.
well, I mean, if this is common practice, and it, I guess it stands to reason if you have to move the room, and you don't know that you're gonna have to remove the room until the last minute, then posting it at the last minute is the only option that we have. Have you, Member Nee, has this been done with some regularity? Is it fairly common practice?
I wouldn't say it's been done with regularity, because we haven't faced this particular situation very often. But when we have faced it, this has been the common practice, that we move the meeting and we post a note on the originally assigned meeting room that the meeting has been moved, and we indicate where.
Yeah, okay. Well, okay. I just wanted to raise the issue.
It's appropriate.
Yeah, and I think it is an issue because I was waiting, down the hall, sitting down outside of the room, and Member Nee had to say, Allison, the meeting's been changed.
I will say that the notice of venue change could have been posted a bit more conspicuously. It's down on a sheet of paper in the lower right-hand corner of that bulletin board, not not readily at eye level. And it seems to me that steps could be taken to make sure that the venue change notice is a bit more conspicuous.
Would there be any objection to me trying to see if Jerry's in the office and maybe give him a quick call and see if we're okay on this?
I have no objection. If the chair wants to declare a say, a 5-minute recess.
Yeah, because I bet he knows this off the top of his head. I don't, and so I would feel better if it was checked that very quickly. I don't mean to hold up the proceedings, but I just want to make sure that our notice requirements have been met.
Okay, so recess is called at 4:10. 5 minutes. Compliance Amendments Committee of the Sunshine Ordinance Task Force is called back to order at 4:18. Member Snyder?
Yeah, so DCA 3 was not in or was not immediately available. So I left him a message and asked him to get back to us and posed the question to him. It sounds like this is relatively common practice. We've corrected the room number.
I'm sorry, I have an emergency. You're a supervisor, aren't you? No? Okay, I'm looking for a supervisor.
Okay.
I have a public safety emergency. The highway patrol is hunting me down.
Wow. I'm not sure whether to be offended or not that I was mistaken for a supervisor. I don't have a final conclusion on this, but it sounds like this is fairly common practice. We have posted the correct room number. We posted it, as soon as we reasonably could after we knew that we couldn't be in that room. So I'm not sure there's anything else for us to do. I mean, if DCA 3 gets back to us and says this is all wrong, we would have to, we would have to go back and kind of redo this meeting to put ourselves in compliance with the Brown Act. But I suppose based on prior practice and what I think is a reasonable reading of the Brown Act, I think we can continue barring further advice from DCA 3.
Okay, then. Are there other members have a view on this? Member Nee?
Yeah. There are a lot of sunshine activists who regularly attend our meetings. And their views are often very useful to us, and I haven't yet heard any of them complain when our venue has had to be changed in sudden fashion like this. If they did complain, I think we'd certainly bear listening, but they haven't done so, so I feel comfortable going forward.
Now, I've been on the task force long enough to have had a situation where we had to change mid-meeting. The meeting was called to order, and then it became clear we couldn't stay in the room, and so everybody in the room was verbally told we have to move. But I haven't had a situation where we didn't call to order in the other room, right?
No.
That came in, yeah. So Rick, you're talking about a situation where it was changed before the meeting was even called to order?
That's correct.
Okay, all right. Okay.
All right. I believe let's see. Mr.
Well, the
Russell?
motion was made and seconded.
Oh, for approval, April 12th?
Yes.
Okay. Is there, members, any discussion of those minutes? Members of the public, is there public comment on the motion?
What is the motion?
The motion is to approve the minutes for April 12th.
Yeah, I'm in agreement with the motion that these April minutes are better than the previous past 12 months. So my congratulations to Mr. Russell. So I'm in favor of the motion.
Any other public comment on the minutes? Seeing none, Ms. Russell, would you call the roll, please?
Yes, Madam Chair, on the motion, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, 5 ayes, the motion passes.
All right, so would you call the next item on the agenda, please?
Item number 3 is approval of July 10, 2011 regular meeting minutes.
Move to continue.
Second.
Discussion?
Madam Chair.
Member Nee?
Yes, this revisits the issue that I raised, with the minutes of March 8th. Here on packet pages 12 and 13, item numbers 4 and 6. parties in interest, updated members on the status. That to me is an incomplete summary. A brief summary of what they actually said, I think would be more helpful. Again, on item number 6 on packet page 13, the parties in interest stated their positions. A brief summary on what those positions were, I think, would be helpful. Packet page 14, item numbers 7, 8, and 9. Packet page number 14 and 15, item 10. Again, I believe brief summaries of what was said by the parties in interest would be helpful.
Members? Member Wolf?
Yeah, I would just say, I'm not carrying the documents from those hearings with me, so for this meeting, to prepare, all I have is the minutes. So without having to dig up, or if I had subsequently discarded those minutes, that item, or had not looked it up on the net, then it does make it easier for us and members of the public to understand what's going on. Some of these cases go back a really long way.
No, I agree. I think we've seen the evolution of the minutes to where we're getting pretty close to having, I think, what we require and what the Sunshine Ordinance requires us to have. The motions are quite clear. We are, I think, capturing the sense of what the public is telling us in each case. But yeah, we need some more details about the status of the case. It's really critical when our committee decides to refer this on somewhere else, that we can better understand our reason for doing that.
What other item?
Member Wolf.
I just want to commend Mr. Rustin for being vigilant about putting the time code, the timestamps. That's really helpful.
Is there any public comment on the minutes from July 12th?
Yes, thank you. Thomas, take a minute. Yeah, I would agree with the motion. If you look on page 52 in your packet, regarding Mr. Pitts, I did speak in support of Mr. Pitts. But what did I say in support of Mr. Pitts? I mean, that would be helpful to the public to understand the evidence offered in favor of Mr. Pitts. And then if you look at the next sentence, Catherine Stefani detailed her response. But what did she say in her response to make this task force decide the issue? The public, again, your proceedings are not televised yet, so the public's relying on your minutes. They're not going to go to your audio for 4 hours and try to figure out what was said on this item. So the minutes have to step up, and at least in this matter of Mr. Pitts, they don't reflect what transpired, what evidence was offered, and what evidence was accepted by the task force.
Thank you. Are there any other comments by members of the public? Okay, seeing none, the matters back to the task force.
Madam Chair.
Yes, member Nate?
Not in the minutes itself, but on the agenda, it says approval of July 10th, and July 12th is the correct date.
Oh, okay. Mr. Rustin, would you call the roll, please?
Yes, Madam Chair, on the motion, Member Snyder?
Aye.
Snyder, aye. Member Lee?
Aye.
Lee, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 5 ayes, the motion passes.
So next meeting, we'll revisit the minutes from March 8th and July 12th. Mr. Rustin, would you call the next item on the agenda?
The next item is hearing on the status of the July 26, 2011 order of determination of Lisa Gomez versus the Department of Public Health.
Okay, so the complainant is present and the respondent as well? Okay. So Ms. Gomez, you'll have 5 minutes to update us on the status of your complaint.
Minister?
Sure,
Sure.
make a point to speak loudly.
Speaking
Yeah.
This came about because I have made requests to the Department of Public Health, specifically Mr. Rivard and Dr. Bhatia, Dr. Bhatia being here now. After that night, after the meeting on the 26th, I followed up with another request that specifically asked for communications from any attorney communications that might provide in specific substantiation for the department's specific interpretations of the code. The department did a few days later send to me some further documentation which had been in existence for a long time apparently, but never provided to me previously. Oddly, all of the prior documentation in fact supports my interpretation of the code, and it doesn't support any of their activities. What further, there were draft revisions of the code and procedural revisions of, I guess, the department's procedures, which do precisely, which I'm precisely looking for the basis in the code for those. The procedures would be to further dilute the noise ordinance, to loosen the standards, to allow more noise, to, for example, in the code and in the legislative history of the code that was delivered to me, it makes specific reference to an L99 standard, which means that when you take a noise reading with a noise meter, more sophisticated noise meters will have an ability to read out to you what's called L90 and L99 readings are. L99 is the lower, it's like the 1% of sound. So if you're taking the ambient, it looks for the lowest 1%, or if you're taking the noise, it looks for the highest 1%. The legislative history specifically references an L99. In the proposed revisions, they specifically seek to move it to an L90, which of course would move the range in. So the way that you determine whether someone's in violation is you take an ambient, which is the lowest noise reading, and then you turn whatever machine is on, and you take the noise reading there with the machine on, and you look at the difference, and you apply a proper standard. Residential is supposed to be 5 decibel standard, commercial is 8. And so the legislative history specifically references an L99. So you take the L99 of the ambient without the noise on, and then you turn the noise on, and you take the L99. So you look at the extremes. The department is enforcing and in fact actively undermining those extremes and looking at L90, so it pulls in the ranges, therefore will minimize what violates. So anyhow, I'm looking for any information that would support that sort of undermining of the noise ordinance, and what I got was in fact further evidence of information that further supports my plain reading of the code, completely unelaborated, unembroidered, straightforward. This is what the code says to do. Whereas the department has consistently given me very elaborate circumlocutions of how they do what they do. And they have never provided any basis on which they could claim that they are acting within the law. And of course, you know that when the government acts without legal authority, they act illegally, or government only has the authority that the legislature gives them. So I have not received anything in specific. I have asked for interpretations or communications between the department and city attorney. My understanding is that the Sunshine Ordinance does not exempt those from the public view, and I have not received any of those, nor have I received any express statement as to why certain items would not be deliverable to the public, which I understand the Sunshine Ordinance and the California law requires. So neither have I gotten an item of things, a list of things that say not disclosed because of such and such a section. I've received nothing like that, nor have I received the interpretations that I've been looking for. Again, I restated my request as of July 26th, for the business day of 27th. Today is 14 days. I have received nothing. So, continuing violation.
Thank you. For benefit of the audio recording, is there anyone here to offer facts and evidence in support of the complainant? Okay, seeing none, the respondent, you have 5 minutes.
Sure, thank you very much. Dr. Rajit Bhatia, I'm the Director of Environmental Health. I've had that position since 1998. Unfortunately, this is my first time in front of you. So I think I'm going to, many of the issues brought forward to you today have to do with the department's interpretation and enforcement of the noise ordinance. I don't believe that those are relevant to the proceedings. There are 2 issues that I believe I'm going to try to respond to. One is regards to our admitted failure to comply with the Sunshine Ordinance with regards to the implementation of the Noise Task Force, and the second with regards to documentation that we have been requested from Ms. Gamez. With regards to the Noise Task Force, and I would request humbly that these 2 issues be considered somewhat distinctly. They are separate issues. We have admitted that we have been wrong in the first issue. However, I don't feel we have failed to provide documents as requested in the second issue. With regard to the Noise Task Force, I think the issue was testimony was offered last time. We incorrectly interpreted our responsibility. We do have experience with public meetings. We have managed various public processes, including the ANCHIA process, the Hazardous Materials Advisory Committee, the Asthma Task Force, the Food Security Task Force, many policy bodies. We've appropriately noticed them all. We know how to do it. We will, and in future we will apply that standard to any meeting like this. In order to make amends with the Noise Task Force, I'm very open to any suggestions that you may offer us. For the Noise Task Force was largely focused on implementation of the noise ordinance and cross-institutional collaboration, but we can have meetings to go over any policy-relevant documents and policy-relevant discussions. We can have 1 meeting, 2 meetings, 3 meetings, any additional meetings that people think are necessary to do that. With regards to the document requests, I would, just for clarification, the first official Sunshine request occurred in May 2011. In your record, it says document requests occurred prior to that, so I'd like that corrected if possible. We engaged in a long oral and written correspondence with Ms. Gamez. The nature of the correspondence until May 2011 was largely interrogatory. She was asking questions for us to defend our interpretation. We provided there were no existing documents with regards to justifying our interpretation, but we, in writing, justified our interpretation. And those documents are part of the record we shared with her and we shared with you. They were ongoing written communications. We never did anything to prevent disclosure. There was simply nothing to disclose. We were trying to interpret the request broadly, as broadly as possible. Subsequently, the documents, we were provided another subsequent request, the same request, and my public information officer, Eileen Schills, responded to that request. We made available some fact sheets that were already on the web that were fact sheets about when the noise ordinance was passed. They were public fact sheets. They were always on the web. We made available some new guidance that we had informed Ms. Gamez was forthcoming on the interpretation of the food safety code. How in our work to ensure restaurant safety are we now going to look preventatively at some of the noise issues? That was not an interpretation or action with regards to the noise ordinance. It's with regards to our food safety ordinance, but it was related, and we provided it. We provided her, and I think she mentioned to you, drafts of legislation changes that were being discussed at the Noise Task Force. Again, this, I think, relates to the first issue, the Noise Task Force, documents that were shared among members, but not publicly noticed and made public available incorrectly by us. And we will continue to provide any documents that we create that are germane to her request. I'm a very strong proponent of transparency and public accountability. In my view, public health can only be supported from that kind of transparency. I want more members of the public at the meetings that I have. Because the public will defend public health interests. So if there's any other document that you'd like me to provide, if there's any other way we can make up for what we didn't do with the Noise Task Force, I'm very happy to hear your suggestions. I'm very happy to implement them.
All right, is there anyone here to offer facts and evidence in support of the respondent? Okay, seeing none, the matters with the task force.
I'll go first.
Okay.
So I appreciate the admission around the Noise Task Force and its non-compliance with Sunshine. And if you feel that you need any further guidance with that, we have a education and training committee that can be contacted, or our administrator for any help. But I'm sure that you cover that on your own, especially with the Health Commission, because they more or less cover Sunshine on their own pretty well. I have a question with regards to one of the things that was difficult during the case was to understand that here's this ordinance, but there was no documentation with regards to how it should be implemented and what areas or level or actions on enforcement can or would be taken and by whom. And so the question here is are those documents available?
In my view, the ordinance itself provides the full information necessary for a noise professional to take the measurements and evaluate using professional standards and take action. So the noise ordinance sets the level of the standard. The practice of noise measurements is a professional practice. It's practiced. It's practiced in a context-specific way, using professional judgment. We have no manual on how we take a measurement in every specific case. It would be very, very hard to imagine such a manual. The ordinance allows us to create a document, regulations or guidance, to create greater specificity, to say, for example, in certain neighborhoods or certain situations, do noise measurements in this way or choose this approach to limit discretion. But those don't exist yet. We have, for example, if in the medical cannabis ordinance, in almost all ordinances we have the authority to issue regulations and guidance, further guidance. But in the case of the noise ordinance, we have not yet. We simply have not created those yet. It is not something that we won't consider doing in future. As you have to understand that the noise ordinance there was about a 40-year hiatus in local government activity to improve noise control ordinances related to Ronald Reagan and defunding of the Noise Control Act at the federal level. We are one of the first cities to reinvigorate a noise program. We have adopted modern standards related to modern zoning needs, and we are enforcing it and developing experience. And through that experience, I think we will eventually come to some guidance, but we simply don't have that.
I think one of the concerns that Ms. Gamez has here is that there is no kind of set rule in writing. You have the ordinance, and that kind of lays out how things should be done and implemented, But then there's could be some arbitrarily
Discretion.
some discretion as to what can be done from case to case. Now, not every case is the same, but at least the standards for handling a specific case, or every case, whether it's on the business side or on the residential side, as I understand the ordinance is now arranged, that there should be some set standards so that.
There are standards.
And so are those written down?
Yes, they're in the ordinance.
Okay, but when an investigator goes out or an inspector goes out to do a reading, okay, I mean, is there a document that they use to fill out what the results are, and are there standards built into that document, and are those documents available?
There is the reporting in a record. The record of the measurements are taken by a few people in the department with the expertise, and they're generally done in similar ways, but there's no standard format, no template for those recordings. And I would say that if three inspectors investigated the same situation at the same time, they would take the measurements in the same way. There is discretion. They document and we have provided a record to you, I believe, that has all the communication with Ms. Gomez and all of the records of noise measurements taken for grub, and we can continue to do so.
Member Johnson, I have a question about you had made reference to the standards are in the ordinance, but you had made reference to there maybe in the future you may adopt certain
Regulations or guidance or
Do
procedures.
you talk about those in emails to each other? Does the Noise Ordinance Task Force make recommendations to anybody about them in writing?
So the Noise Ordinance Task Force had, and I wasn't present at those deliberations, the Noise Ordinance Task Force may have, I think the deliberations, to the best of my knowledge, concerned
not their deliberations, but their exchanges with people about, because they exist not to deliberate among themselves, but to provide information, right? Their creation was to make recommendations.
Right. The body of the work, the Noise Task Force had a new set of regulations to implement. For the work we did, the work the Noise Task Force focused on first was, okay, we have a bunch of motorcycles that are illegally operating without mufflers. We did a sting operation for that.
Did they write documents about it?
The police department enforced their ordinance, and the police department had inspection records. So the Noise Task Force coordinated a sting operation between the police department and the health department about we have minutes of those. The police department has their own records of those inspections. So we worked with the planning department to create a new noise map.
So just right there, I understand your description of what they're doing, but when you say we work with, where we fit in, as you're saying, we work with the police department. So there doesn't have to be, but most people don't do things by oral communication, although oral information is required under here. So what I'm trying to figure out is, in the process of leading up to finalized regulations, those documents are all, any documents or exchanges, many of them, I shouldn't say any as a blanket statement, but many of them would be disclosable. And they would be, when you get to the point, not what kind of work you did, but you said we work with the police departments. I'm curious if you received those kinds of, maybe I should ask you, did you ask for any information like that? Did you receive anything like that?
The things that would somewhat fit this description is the department does have what is titled a noise survey. It's a blank form. It's a 8.5 by 11 front, and it has a few blanks, calibration, before and after, and some very cursory little line items that produce only the end result of what the person taking the sound meter reading would do.
Well,
but
that's more
that's
kind of
a-
what Member Wolf, Vice Chair Wolf, Member Wolf was talking about. But what I'm talking about is actual, like,
communications back and forth. No.
would you, let's see, I don't know, maybe I'm going down the wrong path, but you had mentioned that what the documents that you had hoped to receive involved how they were
Working things.
choosing
Mhm.
whatever this L99 was that you were discussing. So in the process of choosing that, there may not be specific regulations, but there may be communications that
Well-
went back and forth between people who are working on it. Is that something that you wanted? Because that's,
Yeah, let me back
I
up for
hear
a
you.
minute. The
I hear you.
L99 is actually something that came out in the legislative history, which is reflected in the code in the sense that the code says the lowest noise level and the highest repeating noise level for the respective points of information that they're looking for, or data points, I guess I'd say. My request had been, because the reports that I had gotten, for example, one of the first reports I got regarding my own property and the noise that, or the adjacent property and the noise there, was a report from one of the techs who came out, the city's techs who came out and did a noise reading. He took 20 points, he didn't say they were the lowest, and he averaged them, which is obviously not taking the lowest, it's taking an average of 20 random points, and then averaging them in order to get an ambient, and then going to the noise level and taking again 20 points and averaging them, and then applying a standard which didn't apply according to the plain language of the code. And so my question had been, where do you get the authority to average 20 points rather than take the lowest? I have asked for communications from an attorney that might substantiate that sort of call. I've gotten nothing that speaks to what I've requested. I haven't asked about motorcycle stuff. I mean, the other things that we do.
some of the information that city departments trade with council is protected under attorney-client privilege. Not all of it, but some of it is.
Some,
So,
but it's presumptively discoverable, and then you have to
That's-
give a reason.
that's right, and I recognize you understand that because you brought that up. But not only city, in the development of regulations, it's not only city attorneys that are doing input, so I didn't know if you had asked for information.
I've asked for anything and
Okay,
everything.
so-
I've asked very broadly, and to speak to one of the comments that Dr. Bhatia made was, though I only became aware of the technical form of asking for a noise ordinance because of a sunshine request, I had been in effect doing it for a long time and legally doing it for a long time since the previous October. And I came to understand that because I had to do a sunshine training myself, and I saw what I was being trained to just respond to, and I thought to myself, gee whiz, these guys have been ignoring me for 7 months now, and I've been requesting these same things over and over and over again, and they've been ignoring me, and they shouldn't have been. And that's was the moment I realized, and I put it then in a very formal request, to which they responded to mostly by giving me my own emails and some public documents from their website.
I'm going to try to I think I understand what you were asking is that, so first of all, the Noise Task Force didn't exist before 2008. So deliberations that led to the current noise ordinance are not the subject of the Noise Task Force. The Noise Task Force existed after 2008. The Noise Task Force did not only towards its latter part of its existence, had policy-relevant discussions. I am sure that those policy-relevant discussions may have included follow-up communication between individual members of the Noise Task Force about certain technical issues. So if there was a deliberation, it wasn't resolved, there might have been ongoing communication.
Have they made recommendations to people in charge of monitoring it, not monitoring it, but implementing the noise ordinance? Like your department, have members of the noise ordinance task force?
As far as I know, no recommendations were made to the Department of Public Health about our own enforcement responsibilities to the noise ordinance. Largely,
Or anyone's?
yes. I mean, largely, one of our roles under the ordinance is to coordinate and ensure that we were trying to increase the prioritization of noise enforcement by other departments. So we made many recommendations to other departments about the accountability enforcement of their own noise policies. Those happen both during the noise task force meetings, but also, before, also apart from them. I can give you an example is that the Department of Building Inspection was simply not enforcing a requirement for Title 24 acoustical insulation requirements for new multifamily construction. It was a 1974 requirement. It was simply not being implemented. And we basically used a Sunshine Act request and asked them, and we got them to do it. So those, I can ask about any of the, I can look to see if there's any communication not part of the noise task force deliberations that relates to the future standards. Now remember, the deliberations have to do with, are we proposing any future changes to standards? We have not had any, we have not had any effort to develop the kind, more refined or detailed guidance to staff about measurement. We have no resources or plans to do so right now. We did issue in May a guidance to what's called my plan checkers, the people who check whether the sinks are adequate and the temperature, the dishwasher is adequate when they check plans before new restaurants come in, and we added some requirements for them to look for, to make sure that the equipment is not noisy, and guidance to noise inspector, to food inspectors when they go out in the field and have to respond to noise complaints, and we've shared that.
May I just add one thing? My request was not limited to noise or to the noise task force. It was about the department's own activities, and so
With regards to the noise ordinance, not the food
interpretation,
ordinance.
implementation, regarding noise.
Ordinance.
Regarding how you implement it. So my point being, ultimately, when it comes to an interpretation as to how, for example, their tech would come out and choose 20 data points and average them, or why they would apply a commercial standard rather than a residential standard when the code clearly clearly defines a property as being residential, that they apply a commercial. Dr. Bhatia has in fact said expressly to me and acknowledged, we apply a mixed-use standard to mixed-use, which is the commercial standard. There is no mixed-use definition in the code. We apply a commercial noise level to residential properties, and we feel that's correct. He didn't offer a substantiation. He made an assertion. They have never provided any sort of basis for their assertions. I'm not saying they don't act and that they're not doing something with the code. I'm saying they've not provided any basis, legal basis or foundation for what they're doing. They have provided assertions. They've provided statements of fact as to what they do. They do not provide any justification for what they do, which is arbitrary. They're doing things that are quite arbitrary.
So the only thing I could say about that is that we cannot enforce what they do under whatever law that they're doing. So whether they do it by arbitrary or they do it by some regulation or not is really not for us to determine. But what we can determine is if there is any documentation that might lead towards either their kind of guidance to all departments or to their own investigators or inspectors on how to go about things. I mean, as in the case with many other departments, like building inspection, they all go through a pretty stringent kind of sets of guidelines and codes, thresholds that things have to be in, and then where the top level excesses are, so on and so forth, and make reports about that. It's fairly formulaic, okay? And I think that's what we're trying to get at here is there any formula that is being provided post 2008 in relation to enforcement of this, of the noise ordinance, the new revised noise ordinance in relation to this case, so that Ms. Gamez can get some idea of whether there is some consistency, and is there such documents, guidelines, or anything that's provided by Department of Health?
There's no document. We are not trying to hide such a document. We believe we are applying this law correctly and consistently. Every point in the city, every intersection, every street is a different point. It has different noise sources. It has a different mix of uses. It requires professional judgment. But we think the standard is a definitive standard, and I think beyond that, though, regardless of whether a place is in violation of a standard or not, we go out there and we try to lower the noise. We try to improve public health. That's our.
I don't think that we're here to judge.
There isn't even a verbal guidance in that regard.
So then it sounds truly arbitrary that it's up to the professional to determine how best to implement.
I disagree because I think have you read?
I'm just asking a question. I'm not making a judgment.
I disagree. I think that the noise ordinance has a standard, and it says that this standard is for this situation. Okay, we are reading that law and applying that standard in that situation. It has basically 4 different situations, in my view. They're related to different uses, different sources of noise, and different relationships between the sources and the uses.
So how would if somebody disagreed with it, how would they go about appealing that?
If they disagree with it,
and then get information based upon that.
If they disagree with it, I think that they could ask the city attorney whether they believe the department is faithfully interpreting the law. If they believe that the law needs to be rewritten or clarified, they could go to a board of supervisor and say, I feel this is, they could say either complain to the board of supervisors and say the department isn't enforcing the law correctly. If we'd be very happy to engage in a public conversation. I think it's hard to talk about it this abstractly, and we'd be very happy to engage in that. But we don't.
Okay. Well, we're just trying to seek any information that may be available for the purposes of Ms. Gamez's case, because what we have found through the hearing was that as you're admitting, there is no information. There is no written guidelines. There is no kind of extraction of the ordinance for an inspector to go out. Like if you had had to hire a third-party inspector, a contractor, to come and do that work for you, would you just hand them the ordinance and say, here are the guidelines?
Yeah, and I think if you look, there is professional. Most noise measurements are taken by private consultants. They look at the noise ordinance and they take measurements. I only have a few staff who are doing it, and they are working very closely together, and they're professional colleagues, and they develop a consensus really on the approach. I think I could provide. I'm just brainstorming. I could provide not arbitrary. The last 10 we could look back at 10 instances of restaurant residential noise conflicts and the measurements we've taken and the actions we've taken. If anyone wants to 5, to see if that's a question of, are we doing this consistently? So I'm happy to provide those. We believe we are doing this consistently.
I will comment that I did early on in the process speak with the city attorney, and she agreed to listen to me but wouldn't comment because, of course, the department is her client. And so if the department would like to give the city attorney the ability to actually speak to me, that would be great. I could talk with her about it, and that would be super. I will add, though, that on virtually every occasion that I have had a report from the city regarding the noise ordinance, there has been a significant, for example, the most recent one regarding Morningstar's apartment and the measurement of interior noise, that noise measurement was taken with windows closed and certain standards applied. The code is quite clear that that standard applies only when the windows are open. And the designation of type of property is a property by property designation, in other words, lot by lot.
But I'm just going to interrupt you because
And
how does this apply to written documents?
Because
or-
the noise survey that was received
Okay.
notes certain things, and often they don't note this is non-violating because of a code section. I had to get that separately from other resources, but the point ultimately being those noise surveys often do not reflect a compliance with the law.
But his question is there further documentation that you've asked for that you've not received? I mean, that's sort of the fundamental question.
I've asked for a comment, any sort of interpretation.
I think you're addressing the question of whether or not they're complying with the noise ordinance in a way that you think they should, and that's fine, you can have that discussion, but our only job here is to figure out, have you asked for documents or communications that exist, that are subject to the ordinance, that they have not provided you? And so
I've asked for any sort of training manual, employee training, any sort of commentary from a supervisor to an employee regarding how to take a noise measurement. I've asked for any sort of communication regarding how, in any circumstance, any noise. For example, this employee, the first noise report that I got, where the individual came up with 20 noise points and averaged them. Does he just make that up?
The question is did you get that?
I did not get it. I did not get it.
So let me.
Yeah, I mean, and so in
Can
other
you
words, is there any employee training? How do they train their employees?
So let's.
I don't understand
let's
how you
start
know
back.
about a document that you didn't get.
Well, so let
something.
me try to maybe go back to somewhere near the beginning, and can you try to boil down a list for us of the things that you have asked for that you have not received?
I have asked for any sort of employee manual, employee training guideline,
Right.
any sort of communication between employees of the department that would provide a basis, for example, of taking 20 noise data points, which I did get a report that did in fact use that formula, but it's not in the code. So anything that would provide any basis for that.
Okay.
Any communication from an attorney that would provide a basis for taking 20 data points rather than the lowest. Any communication between a supervisor and a junior person saying that is or isn't how you do it, correct, well done. Anything that says how you fill out a noise survey, anything that says, any of these very basic, how does employee 1 and employee 2 know that they're doing things consistently?
Okay.
Do they only exclusively speak, right? Or do they, it's...
And have you gotten any
Nothing
documents that address those categories? Okay, now let me ask Dr. Bhatia, are there, I'm just going to go down, there are no, you're saying there are no training manuals, there are no instructional memos, there's no
No
documentation
procedures, no, not for this.
for how to interpret,
Now,
how to fill out a noise survey.
let's say that 5 years ago, I'm just going to hypothetically, 5 years ago in a noise complaint, I have 150 employees. I have one manager, Tom Rivard, who I think you've met, of noise, air quality, and radiation. Let's say that 5 years ago, employee A took a noise measurement and did so incorrectly. Okay, and then we had a subsequent complaint because the complainant wasn't satisfied. Then we have ultimately our expert, Tom, or one of his senior staff, goes out and does the measure, which I would say is using a consensus approach, and does it differently, and does it correctly. He may have counseled employee A that you did your measurement wrong. Okay, I haven't gone back and looked at every communication between my senior staff and employees who may have taken any noise measurement at any time. But I don't think, but that is not a guidance or procedure of how to do it. It's a, hey, do it, you shouldn't have done it this way this one time, and that would be that would mean looking at 5 years of email communications and trying to scan out which ones have to do with noise, and I think that's a fairly, I don't think it gets to I think the interest is, where is the consistent sort of message and procedures, and I'm saying that's right now in a consensus of practice among my professionals. And I would love to, and it would, in order to do what I think that Ms. Gamez is asking, we need to not only bring my professionals together, we need to bring every noise consultant together. We need to bring the building department and the planning department together and have a discussion on what further guidance or specificity do we want for these noise measurements. I think that's a good idea, but it doesn't exist.
But you're sort of veering off the topic that we're trying to focus on here, which is documentation and communication, documentation of communication. So it sounds to me like there may be communications between supervisory employees and employees about how to go about filling out a noise survey, or about what's the best method of doing this. If there is a wrong way and there's a right way.
They're
And if somebody
typically
did it the wrong
oral.
way, then there may have been communications about how to correct that error. And it sounds that, I believe that Ms. Gemma's request addressed that, she has asked for those kind of communications.
I'm not aware of any. I know that my staff have, what Tom usually does is when an inspector is having difficulty with a noise complaint, he goes out with them and takes the noise measurement together with them. It's
Are these, so is
in
this,
the field.
is this process that you're describing, are these filed away? Or do you keep track of and index communications regarding the methods? You seemed to say earlier that there may be emails out there.
There would be any okay, the records of noise measurements are in a file for the establishment. We keep all of our files by establishments. So if you said, give me all of your establishment files for noise, but generally Tom will go out with the person and take the noise and do it with him. It's I don't know, it's not
I understand you're saying that the physical
training is happening in the field.
But the physical operation is done by hand. I mean, they're doing it on site.
You're looking at a meter and you're recording a noise measurement on a
Right.
piece of paper.
Okay, so
then you're looking at the
let's
code.
start with that. Were those documents provided to Ms. Gamez?
Which documents?
The documents of which any notes that were taken during the inspection. So somebody set up a sound pressure level meter or whatever device that they use. They get a reading. They mark it down on a piece of paper. Is that piece of paper?
4758 Valencia, the complaint that she made.
Yeah.
All of the inspection records for that complaint were provided to her.
But what about the actual documents of the work product?
That is the work product. The inspection records with the noise measurements were provided to her for the complaint that she was
And
that she
those
made. Now, I
include-
didn't do it for every
Are
restaurant in
those
town.
include? That's okay. We're only talking about this one.
Yeah.
Were the documents that were used on site during the inspection provided in that file, or was the information from those documents gleaned to create a new document called a report?
I believe, to the best of my knowledge, these are field records. These are
They are
because they're
field records,
hand-scribbled they're hand-scribbled records in the field.
Okay.
Whether the inspector has another piece of note paper or pads, I cannot,
Who
cannot.
finalizes those reports?
It's just the inspector. There's
So nobody from the department or Mr. Rivard puts her stamp of approval or anything like that?
No, Mr. Rivard gets involved in cases that become controversial. Where there's controversy and conflict and disagreements, Mr. Rivard gets involved.
Oh, and then is there any documentation with regards to those
He
communications?
will go out and do an independent investigation.
Okay, and does he
He will take his
those?
own measurements, and those report, those
Those in the
documents,
file?
and those also were provided to Ms. Gaines.
Okay, all right. Anybody else?
Member Johnson.
This is such an overwhelming thing to say to you, but I think it's really important. I thought Member Snyder was going to hit upon it. What you just said about sometimes there'll be a yes or a no, this is how you do it, and it might go back 5 years. Those are disclosable under the Sunshine Ordinance. The amount of time that it would take you to get them, you can provide them on a rolling basis, but literally, if you don't have regulations, those are your regulations. So if you ask, like we had a case where someone asked staff at Rec and Park to go through their emails, and they have to search them. And so if she's asking for things that have to do with when you told them how to do it, she doesn't have to wait until you guys decide to put it all in one place. If you don't have it all in one place, that's not really her problem. And I don't mean that in like a negative, I'm not making a judgment about how they're kept, but it's not an exemption that those things are hard to get. So there has to be at least some way on a rolling basis. And on the other side of that, you know, we try to interpret these things so that it's not, you know, that there are rules in the Sunshine Ordinance that allow you to ask her to narrow the request so that it's not like this random thing where every restaurant you're going to get every single thing. But there may be things that you can search for. I don't know how they're kept. I don't know what your emails look like. But there may be ways for you to search for things that have to do with an incorrect code or a complaint that came back or some. I don't know what kinds of complaints you get. I don't know if they're common, but.
So first of all, I don't know whether any documented record of an instruction
But
from
the fact
exists.
that you don't know
That's
means
fine.
that you didn't look. I don't care
Okay.
about the procedure so much, but the fact that you don't know means that nobody looked. And what I'm saying is somebody needs to look for them to have some kind of a report of whether they are or not there. You know, the idea that we don't know is there's still public records, and they're happening in the course and conduct of the public's business.
May I ask you a clarifying question? Yeah. So if this is what your interpretation of it is, that's fine, but we did not interpret an ad hoc instruction on a case-by-case basis as a guidance, because that's what we were being asked for. If your interpretation as a Sunshine Task Force is that every ad hoc instruction, is tantamount to guidance, then I'll go back. I mean, I would go back and consider that. I don't know how we would. I would ask an employee to remember every time they gave a guidance to another employee, and whether they had a written documentation of that.
Well,
And I don't know how that would be searched. I don't know how that would be searched. I mean, I think that it could be searched by taking all of those emails and putting through some complicated Google program that looked for some, key language. But
Wait a minute. I search my emails all the time. I'm the chair of this task force, and I had to get more memory because I have to search them. I search them all the time. So this idea that it takes some Google program is very disingenuous. Now, I understand what you're saying, and the reason why I sat here and said that it was difficult for me to say is because I understand the difficulty of searching it. But there has to be if there are things that have that the basis for it is not provided in the ordinance. If there are things that's not an ad hoc thing. If she's asking for 20 and you say you don't have them, but we need to have some evidence that they were searched.
okay.
Because I'm not saying that it's on an ad hoc, random basis. I'm trying to say that you can narrow it down because it is overwhelming, and we can't have people coming in and saying, very random, vague things because we would never get the proper answer. But if there's no guidelines and the way that your employees are learning have to do with, if you train your employees on an ad hoc basis, that is helping define a law. Judges do it. It's black letter law, but interpret in a way, that's what we do. So,
Can I just add one?
Before you go, one thing. Let me just try to narrow the issues here. It's my understanding that Ms. Gamma has asked for records pertaining to one address, right?
Correct.
No, at the outset, yes. But by the time I got to my specific sunshine request, I asked for any guidance.
Okay.
I asked for anything
Did you
because
ask-
he was giving me nothing.
Okay.
And then let me just add that the report that I did get, the original report where he took 20 data points, I watched the tech take data points. He wrote them down. When I had a sound consultant, he has a machine that actually is a computer and it logs everything, and so it can create a chart that gives you exactly what the machine logged. But here we have humans logging numbers. I didn't get those logs. I only get a number that they picked and they wrote down on a summary data sheet. But all of those logs, nothing.
So are those logs contained in the file?
I don't know
You don't know.
what a restaurant inspector keeps. I know that the restaurant inspector, they're supposed to get the lowest repeating number and use that to compare against the standard. So
How are these files kept? Are they physical files?
They're
How-
physical files.
How big is that? How much space do they all take up? How many file cabinets are they
For what? I have several regulatory programs. There's the food program, the hazardous materials program. There are
in?
a lot of
Okay, so for
6,000 restaurants. There's 6,000. Well, noise. The noise files aren't kept in a separate place. The noise record, the noise files may be kept in a separate place if it's not a regulated business. If it's a permitted food establishment, then the noise complaints will be kept with that file, unless Tom Rivard gets involved. Tom, the supervisor, gets involved, then he will probably have a separate file.
So does he have a file for most of the? Sounds like he would have files
For the
sorts
controversial
of things that Ms. Gammas is curious about. For instances where somebody went out and did a report.
We could look at the for example, name a subset. If you named a subset, restaurants in 2010, where Tom went out and reviewed the restaurant inspector's noise readings, we could pull the noise measurements the noise inspector took and whatever that Tom took and provide those if those would be helpful.
So
but
one
you
thing I
have to
want.
know how you interpret those.
Well,
We've told her how we've interpreted in emails to her. We've tried our best I've tried my best to explain how and why we interpret it.
So she asked for communicate. I'm going to go back to you were saying it's difficult. You didn't understand the request to be for ad hoc.
I didn't.
And that's understandable. However, my understanding is she asked for communications, and that's a fairly clear request. Communications means, do you have emails or other written communications about this issue of guidance in interpreting the noise ordinance and how a method of doing that is arrived at? What's a good way to do it and what's a bad way to do it? And it sounds like there are these kinds of communications, and if they're ephemeral and they were verbal and they were 10 years ago, then nobody expects anyone to keep a record of that, and you don't have that communication. That's totally reasonable. However, if there are emails that that are communications regarding the interpretation of the noise ordinance, two things. One, I suspect they're not all that hard to look for, and two, that would appear to me to be fairly clear, that would fall fairly clearly under the category of communications regarding, and I'm not sure how the best way to phrase it, but communications regarding methods of interpreting the noise ordinance or implementing the noise ordinance. So
just to clarify, I did ask for communications documents, training manuals, videos, anything.
That's different than ad hoc guidance. I mean, what you're saying is, how do I know whether in 2005 at X address, whether someone walked out there and told the guy, you need to do it this way, not that way. Well, of course, there's no way you can know that, and there's no way to look that up. But you've got to have, or maybe you don't, but I suspect you do have some kind of indexed system of documents that relate to this, and it may be email or it may be a file.
We have a database.
And if you have a bank of file cabinets that have all this stuff, one option is to say, we could spend a lot of time, and it's going to take a long time for us to go, or come on out and look through them. Come on out and look through our files.
You're welcome to come and look through our files.
Excuse me.
Member Nick.
Unfortunately, what's been going on back and forth here for I don't know how many minutes really has nothing to do with the order of determination. We're here to look at an order of determination and determine whether there's been compliance with that order of determination.
Thank you.
On that order of determination, I see absolutely no instruction for the respondent to provide any kind of documentation to the complainant. That should have been done at the full task force meeting on July 26th. Whether there should have been certain specific documents provided to the complainant, that should have been determined on July 26th, and that should be reflected in the order of determination before us today. I don't see it there. Moving forward, I will say that I will have some recommendations regarding the public, the open meetings aspect of what the NOTF has done. But in terms of the public records aspect, I don't think there's anything further that we can do today.
Madam Chair.
Member Wolf.
Respectfully, I disagree. The complaint was specifically for records, and those records were not provided. And so the order of determination was in violation for not providing those records, and we're here today to try and get compliance of that. I think it's very clear. I mean, that's the way almost all our orders of determinations are done. We don't.
It is missing our 5 business days.
It's automatic. You don't have to state it.
Yes, you do.
It's in the ordinance. It's automatic. It's part of the violation. It's in the violation that's been ordered. It's not. There's no requirement in our bylaws or in the ordinance that says that we must state in our orders of determination that it must be 5 days.
I do understand what you're saying. I think it is preferable if we had it in there, although I can't recall if we said that at the time, and that's why we didn't put it in there. And I had listened to some of these when I went back, so it's possible that we didn't say it at the meeting. But nonetheless, I agree with you that
It's implicit.
That it is implied that you would, if we're finding a violation for not turning them over, it will affect what we can make recommendations to you about the task force, because we didn't have him here to comply with the order. He did appear.
Madam Chair, I've not seen in most of the orders of determination that there's a requirement or there's an order that they should produce anything in a certain amount of time. It's implied in the ordinance already that once the order of determination is made, that compliance must be made within 5 days of the violation.
That's my understanding.
Madam Chair, can I ask Member Wolf or any other member of the task force which section of the ordinance makes that stipulation?
I don't have the ordinance in front of me.
I have a take on this. Look, I mean, I guess I have to agree with Member Wolf, at least partly. I think the ordinance probably does require further compliance, but it can't be if we don't ask for it. We'll start earlier and say, I mean, the point of this meeting of the Compliance and Amendments Committee is to determine if the violation which has already been found, to determine if the entity which the task force has already concluded violated has since produced records or in some other way complied with the ordinance in order to determine whether we take further action or not. We can drop it here. We can take further action if we conclude that that there hasn't been compliance.
If I may.
Well, wait,
But if we don't, if the order of determination doesn't include any instructions, I don't think it's fair as a matter of due process to require the entity to follow further instructions if we don't give them. I mean, I think this process can be opaque enough as it is. If there's not some clear instruction saying, please comply within a certain amount of time or else.
So you're in agreement with member name?
Yes.
Member
Unless
Wolf?
somebody can point me to
Um,
language.
Member Wolf?
6721E states that Sunshine Task Force shall inform the petitioner as soon as possible in the 2 days after its next meeting, but no case later than 45 days from when the petition in writing is received. It is determination whether the record requested or any part of the record requested is public. Where requested by the petition and where otherwise desirable, this determination shall be in writing. That's this, what we're doing here today. Upon determination that the record is public, Sunshine Task Force shall immediately order the custodian of the public record to comply with the person's request. Well,
It's just.
if the custodian refuses or fails to comply with any such order within 5 days, the Sunshine Task Force shall notify the district attorney, attorney general, or who may take whatever measures, so on and so on and so forth.
We didn't make an order, though.
That was, I recall that.
Excuse me, Josh.
The order of determination,
I think we just failed to state that at the meeting, and when we failed to state that, and then we failed to follow up with it in the order of determination to specifically state to turn over the documents within 5 days. However, Ms. Gomez did follow up on July 26th with another immediate disclosure post. Now, that would be a separate complaint because that's due process. So, I agree with Member Wolf the same way that Member Snyder did, that obviously if we're finding a violation, not turning over the public records, we're saying that they're disclosable, but we did fail to make the specific statement. So, but that's going to affect how we make a recommendation to the task force.
I mean, all that said, it appears clear to me, just speaking for myself, that Dr. Bhatia and Mr. Rivard understand, at least, they understand the nature of the problem, and it appears that they have taken some steps to ameliorate both the open meetings problem and the records problem. And it's my understanding the meetings problem may not be an issue anymore after September, but they're also, it seems to me, based on the fact-finding we did at the task force meeting, that there may well be further records out there that are producible that haven't been produced. That's just my comment. I don't have a conclusion.
And then, the one thing I do disagree with that Member Nee stated was that we were discussing something that wasn't necessarily, we can't enforce it, but at least we have this conversation going forward. We're all on the same page that this is the information we're seeking, and these are the things that we expect. I mean, this is what we consider public, at least, so that we don't have to have that part of it repeated. For example, when Member Snyder was explaining about the communications, that this is what we expect. This is what we think of as public.
Member Wolf?
Madam Chair, on page 19 in the decision order of determination under number 3, in the second sentence, it states that the Noise Ordinance Task Force was ordered to show how the violations have been rectified. That's an order. Further, it states that the Compliance and Amendments Committee was ordered to refer the matter back to the task force with a recommendation. And then on page 20, it states the letters are to include copies of suggestions, if any, made by the Noise Ordinance Task Force to the Board of Supervisors. That's an order. That's what we're here for, and that's what we're discussing. I don't see how we're going beyond any kind of scope or something that's not included. In number 1, it just states what was the violations with regards to the Noise Ordinance Task Force in regards to the Brown Act, that's already pretty much dispensed with at the beginning of this discussion. And same thing with, and then number two, same thing. Okay, it's number 3 that we're dealing with here with regards to that there should be any and all documents or information to show how the violations have been rectified. So with regards to, that's what we're trying to find out. We're trying to find out if any of the documents that Ms. Gamez had requested, which it has been rectified.
That doesn't match my reading of this at all, member. Well, it looks like at the bottom of page 19, the orders that we made, that the full task force made to the Noise Ordinance Task Force were regarding public meeting law violations. So at the full task force meeting, we found them in violation of pretty much all of the public meeting laws, and we asked them to come before us today
Those minutes.
to tell us what they've done to rectify this problem.
And
And-
that's also regarding Mr. Rivard.
And then we had another set of findings regarding violations of public records laws. And we don't specifically say that, order the Noise Ordinance Task Force to do anything, although
All that means is that we can't do anything about the order of determination. It does not mean that the documents are not disposable. I mean,
They were shared.
I have no control over what it is. These are here, this is the ordinance, and they're still disclosable. So it doesn't mean that what it means is we couldn't say, if we had to enforce the order of determination, there's nothing to enforce. But it doesn't negate what the Sunshine Ordinance requires you to turn over.
Can I make one point?
We have to,
May I make one point?
yes.
I'd like to just point out that in the conversation today, it is clear that there are very likely documents that are discoverable, that Dr. Bhatia has consistently said that he doesn't know whether or not documents exist, that this is a very clear statement that he hasn't looked, and he nevertheless just interjected that everything has been shared. So I would like to just point out the disregard for public rights, public information. He doesn't know, on the one hand, but then he insists that it's been shared with me. That's a clear contradiction in information, at the very least.
I'm wondering if now is, if we want to.
I think you
Excuse
should give
me.
me an opportunity to respond to that if you gave her an opportunity
Yes.
to. I mean, I think,
Excuse me, my point of order, it seems to me that the parties in interest are not running the meeting here, we are. And the parties in interest will have their opportunity to make concluding and rebuttal.
okay, that's fine. Thank you.
All right, I think the task force needs to get on the same page right now, so.
I just need to ask you a question.
Yes.
Member Johnson.
Through the chair, this is the exact same issue that I'm having a conversation with you and Mr. Freed. The order of determination is not reflective of necessarily what was going on. Can that be amended?
Well,
Can that
yeah,
be-
yeah, well, we should talk about this later, but the issue is
But
when.
that's for this, right? Because
Well,
we're not.
the issue is when it can be amended, or when we have an editing process after the task force issues the order of determination, we check it to make sure that it accurately reflects what the task force's will was. Once that order issues and goes to the Compliance and Amendments Committee, I think it's a different game. But let's talk about that later. I just wanted to make a quick point. We actually have very specific instructions from the task force, this committee does, about what we are supposed to do here. We're supposed to refer it back to the task force with a recommendation that letters be sent regarding the violations. we could, I suppose, have also taken further steps here, but I don't think the inquiries that we made were either unauthorized or to no good end. I think the fact, I think what we've learned here today can inform our referral back to the task force and instructions, if they're that, about what the letters should say. The letters that are to be sent to the Director of Public Health, Board of Supervisors, and the Mayor.
Since that was my
So all that said, I think it's difficult for us to, for instance, I think it would be hard for us to find a willful violation based on continuing failure to produce because we didn't specifically, the task force didn't specifically request further production by the time of this meeting. So
Member
that's all I
Johnson.
wanted to say.
Member Johnson.
The reason why we did that partially is because it was such a huge, if you remember, I thought it was one, if you remember the meeting at the very end, I thought it was one issue. And then Member Wolf corrected me and divided it into two, the Department of Public Health and the Noise Ordinance Task Force. The reason why that instruction is there about the letters is because it's so humongous that there are no one specific document that we can say turn over. As you can see, we're kind of doing here what we might have done at the task force. So we want to know how this is going to be rectified, that no public input has been put into what has happened with the noise ordinance. That's why that recommendation was in there. That I wanted to make sure on some level that didn't get slipped through. And in fact, my initial recommendation was to ask the Noise Ordinance Task Force and the Department of Public Health to write their own letters and show them to us. And Member Wolf said perhaps that's out of the scope of what we can order. But we could do it ourselves. So we want this to be rectified, that the noise ordinance is basically gone without any public input, and the task force is representative of that. The task force not being public and making the recommendations. So we knew that the Department of
The
Public
Noise
Health,
Ordinance Task Force.
yeah, the noise ordinance task force, but we knew that the Department of Public Health was aware of the sunshine ordinance. So those letters had a specific intent. Now, here we kind of want to say, again, Member Nia is correct, we should put that 5-day in there anyway, but that's, just so you know that those letters have a specific intent, and it's to alert the people that are supposed to be responsible for the noise ordinance of the Board of Supervisors that no public input has happened.
Member Wolf.
Yeah, I mean, that's why when I had spoken on this issue during the original hearing, I said that I was only going to be discussing the violations of the task force itself, and that I would, because that's what, it took me a long time, a lot of research hours to determine what that was, that body was, how it was created, what it was supposed to and not supposed to do. And then finally, the letter from Eileen Shields came and said, yeah, we're in complete violation, and we'll get that corrected. So I was not, my interest was only in the Noise Ordinance Task Force's violations, and that I specifically said I was going to leave the other points with regards to the documentation that Ms. Gamez was trying to receive from the Department of Health separately for the task force to deliberate, which is what I did. Okay, so looking at this order of determination, now I haven't reviewed the minutes from that meeting or the tape, because I'm assuming that the way this is written is correct. So if I'm to assume that the way this is written is correct, then it's only focused on the Noise Ordinance Task Force, and it's not focused on the document requests that Ms. Gamez made to the Department of Health, even though her original complaint was for both, that she had not, that there was a violation of no public access for the Noise Ordinance Task Force, plus that she did not get information regarding the same incident from the Department of Health with regards to the noise ordinance for that particular incident. So I'm going to leave it at that. And
We didn't discuss a specific incident. I mean,
I'd like to move this meeting along. I think, I don't want to go back and, rehash what we discussed at that very late hour several weeks ago. And I think we have some things that we can accomplish today, and I would entertain suggestions from the committee members about how best to proceed. We haven't yet given the respondent and the complainant an opportunity for rebuttals. And so, Member Nate.
I would suggest we have the rebuttals now, concluding remarks and rebuttals, and then see if any of us has a motion.
Okay, all right. So, first the respondent, you have 3 minutes, and then the complainant.
Okay, I think I can be brief. Again, I think there are 2 issues in front of us, the noise task force. As far as I know, we have not produced a final report with concluding recommendations. We will comply with the noise task force, with the sunshine ordinance for future meetings. If there's any specific recommendation that you have for us to make up for the fact that we didn't have open meetings with regards to policy relevant discussions, please give them to us and we will implement. I will do that. I have no issues doing that. It is in my interest, in the interest of noise enforcement, to do that, and I'm very supportive of that. With regards to documents, we have provided, again, a 100-page document request and another 62-page response. We are trying, based on our interpretation of the request, to provide everything that we thought was relevant. If there is something else, and if a further request can be narrowed down, for example, all instructions from person X to person Y during X time, we'll do due diligence. Since the noise ordinance was, if you can formulate such a specific thing, we will do our best to recall and search for those records. We don't have a mandatory responsibility to retain emails. The Department in the Department of Public Health's record retention policy, the DTIS, we may have to ask DTIS to recover certain documents. So I think a specific request, search terms, whatever. Give us a little bit of specificity, and I will try to comply. And again, we have nothing. We have nothing to hide. So if you can be specific, I will do my best to comply.
Thank you. Ms. Gammage, you have 3 minutes.
Thank you. I'll just point out that as to both Dr. Bhatia and Mr. Rivard, that the task force found them in violation of Sunshine Ordinance Section 67.21 for preventing public access to public records, 20.22 for not releasing oral public information, 0.25 for not responding in a timely manner, and we're talking since last October. 67.26 for withholding records, and 67.27 for not providing written justification for withholding records. Right? Those have been findings that have been made as to both Dr. Bhatia and Mr. Rivard. I will add further that had they at any point, the Sunshine Ordinance provides them with the opportunity to communicate with me, to clarify, to cooperate, to coordinate, to ask for anything narrowing. We're now going, it's now August, we're going on a year since the original requests were made. They have never done so. They have never reached out. They have never asked for me to narrow anything. They've never put forth what their interpretation of my document request was, so that I could understand how they were narrowing it and how I could clarify for them. Right? It has been an authoritarian, one-directional assertion of their autonomy as to everything that is in their purview.
Oh.
I will further state that the Noise Ordinance Task Force is sunsetting next month. It's been in effect for 3 years. I don't know what you can do at this point, but 3 years of public information have been robbed. The reason that the department at this point has nothing to produce is because the public has had zero opportunity to go in and say, what is going on here? There have been 2 or 3 meetings since I have started making my protests, and they have completely blown me off. And if I had had the opportunity, I could have gone in among their peers within the city and gone, it's funny here, what you're suggesting, the restaurant procedures guidelines, actually doesn't correspond with the code in any way. Could someone here please comment on that? And then we would have had a process. But the damage that is done by allowing this process to sunset quietly is horrible. It is affecting real people's lives. Dr. Bhatia is also a medical doctor. There are medical doctors in the information that I submitted to this ordinance commenting on the harm that is being done to Morningstar, the person who is living above a restaurant and below machinery, and whose life is being disrupted, whose sleep is being disrupted, whose peace of mind is being disrupted. I would hope that this department, or this task force, would take these concerns extremely seriously.
Thank you. Member Nate.
I have a question a couple of questions actually for Dr. Bhatia. First of all, did I hear you say that there is no requirement that emails be maintained and preserved?
The department doesn't have a specific record retention policy with regards to
Okay,
emails.
I suggest that you do, that the department develop one. Section 67.29-7A. The mayor and all department heads shall maintain and preserve in a professional and businesslike manner all documents and correspondence, including but not limited to letters, emails, drafts, memorandums, invoices, reports, and proposals, and shall disclose all such records in accordance with this ordinance. Second question I have: did the Noise Ordinance Task Force take any definitive votes during all this time that it's been in existence?
As far as I am aware, no. They have not produced they were mainly focused on implementation and coordination of multiple agencies' enforcement responsibilities.
There were no motions to do anything?
As far as I'm aware, no.
Have you gone back and reviewed their minutes or listened to tapes?
No, but as far as I know, and based on my conversations with Tom Rivard, who chaired the meeting, there was deliberation and movement towards consensus.
And has the Department of Public Health taken any definitive actions as a result of what's come from those discussions by the NOTF?
The Department of Public Health has not taken any definitive. The Department of Public Health has facilitated the coordination of the implementation of the noise ordinance based on priority issues at the task force. For example, the building department's enforcement procedures and the motorcycle issue. But we have not changed our regulations or implemented our regulations in a different way because of the deliberations.
Member Ward.
I just wanted to correct what I had mentioned before. Looking at the orders of determination on page 20, there are 2 motions. There were 2 actions taken. One would they were separated because each incident was distinct of themselves. And I think that's what Ms. Gamez was trying to point out earlier, which called my attention to it. The first motion, which is at the top where it says this order of determination was adopted, that was specifically for the Noise Ordinance Task Force. And then in the next paragraph it says the task force also finds DPH and Dr. Bhatia in violation of the ordinance in those sections, and then there was another vote taken. section 6721, it was the complete section. So it starts at the beginning of how that process is supposed to go. And Ms. Gamez had, in her testimony, if I remember correctly, had gone through every single aspect on her own to the point of not getting the information that she wanted. So 6721E, which is inclusive, which requires after the order of determination that has been made, which we have in front of us, that the information be provided within 5 days, is, I think, in order. I don't think it's out of order. The question is whether what we're trying to do here in the Compliance Amendments Committee is just to try what can we do to help attain compliance so that the complainant can get the information. It's somewhat in the same way, a court would try to help a plaintiff to get discovery. We don't have subpoena powers. We can't force people to do things, but we try to at least, use the ordinance as a way to try to help guide everybody to come to that level of compliance. So that's what I'm interested in. That's why we keep asking these questions, because in other cases it's kind of like there isn't just this kind of like somebody goes in, they do something, and they file a piece of paper. There's always like some staff meeting, there's some emails, there's a phone call, there's some correspondence between various people, especially if there's a third-party contractor that is doing work contracted by the city. They have to provide specific written information, and if there's any specific guidance that the city has placed upon them, that usually is in writing too. So that's the kind of the force of the questions that we're asking, because Ms. Gamez is saying that those things are missing, and so that's why we're asking all those questions. So I think for part one, I think is clear. We've already dealt with part one, and the order is clear on what this committee needs to do for that. In part two, if there's any, I'll leave it for any other discussion from any other members before a motion to be made.
Yeah, I would suggest two motions on this. One to deal with the public records aspect, one to deal with the open meetings aspect. And I am prepared to make a motion on the latter.
Okay.
I would press.
Member Johnson.
Is there such a thing as making a motion to refer the order of determination back to the full task force because it doesn't properly reflect the intent of the full task force? To turn over documents and have it amended?
See why not?
Member Nate?
Well, I agree with Member Wolf. I don't see why not. However, again, I would suggest that be taken separately, because there is.
I'm understanding.
Well, what's not in the order of determination really deals more with the public records aspect. And so what I'm suggesting is we have two motions on this. The first deals with the open meetings aspect. And then for the public records part of it, I would say that a motion to revisit the order of determination certainly would be in order. That's my interpretation, and perhaps
A motion to have
I would like to weigh in.
A motion to have the task force revisit, you're saying? Move to refer it back to the task force to revisit the order of determination. Yeah, I don't see a procedural problem with that. One thing to consider is whether it's fair to the agency to require them to come to reappear at the Compliance and Amendments Committee based on our mistake.
You mean the task force? I'm sorry.
Both. Well, I guess they're probably going to have to reappear at the task force, but in any event, but my understanding of what we're doing is, what you're suggesting that we do, is refer it back to the task force to say, you got to redo the order of determination because you didn't order them to produce documents, so you need to do that. The task force then reissues the order of determination saying, produce documents in 5 days. I assume then it comes back here, and they've got to show back up here again, based on our mistake to do that the first time around.
Well, you don't
Just-
have to refer it back here.
I guess that's true. We could just say,
Well, they can let me know if there was compliance.
yeah, I mean, we could say,
Well,
We can make a motion and discuss.
Member Nate,
Give it a
Member Nate was
motion.
about to make a motion.
well, no, let me just coattail on for a second on what Member Schneider was saying. We don't have to refer back to the task force for rewriting the order of determination. What we can do is make a determination here that the public records requests of the complainant were not met. And we can make a declaration here today that the respondent is ordered to produce those documents by the time of the next task force meeting, and is ordered to, both parties are ordered to appear at the next task force meeting to give us an update on whether those public records requests have been met. And then it's up to the full task force to determine what happens if the public records requests have not been met. And at that time, we don't have to refer it back here.
yeah.
If the public records requests have not by that time been met, we can refer it back for willful violation.
So is that a motion?
No, that is not a motion. My motion is going to deal with the open meetings part of it. I believe
Member Welch?
Yeah, I mean, that could easily be done. We can make a declaration here in communication back to the full task force. And then the full task force can do it as like a committee of the whole, as a compliance committee of the whole. So it would be like, we would all, do it in that kind of fashion. It's just a formality. But that certainly, I would agree with Member Nee that could be done. So we would only take action on one item here. The second item would be a declaration of our findings of what we found here today, reporting, and a report back to the task force, and then let the task force dispense with it at the next meeting.
So do we need a motion in order to refer this back to the task force?
Yes.
Yes.
Okay.
But we're going to do it in two parts. So let's do the easy part first, which is the
I'm not
open
so
meetings.
sure it'll be easy, but let me tell you what it is, and we'll go from there.
Okay.
Madam Chair, I move that the Sunshine Ordinance Task Force urge that any and all actions taken at sunshine violative meetings of the Noise Ordinance Task Force be declared null and void. That we send a letter to that effect to the Noise Ordinance Task Force, to the Department of Public Health, to the City Attorney, to the Board of Supervisors, and possibly to the Mayor. We can discuss that during deliberations on the motion. Again, my motion is that the task force, that we recommend that this committee recommend to the task force an urging that any and all actions taken at sunshine violative meetings of the Noise Ordinance Task Force be declared null and void.
Is there
A
a second?
second?
Madam Chair.
Yes.
It seems to me that the lack of knowledge of the sunshine ordinance on the part of the Noise Ordinance Task Force is not an excuse. It seems to me that when people agree to be on a body such as the Noise Ordinance Task Force, they have a certain responsibility to know what their responsibilities and their authorities are. They obviously did not take that responsibility seriously, nor did the, who appointed the members of that, who formed the noise ordinance task force?
Board
Department
of
of Health.
Supervisors formed it,
Board
and
of
the Department of
Supervisors.
Public Health staffed it.
Okay, so there was also a responsibility on the part of the Board of Supervisors, on the part of the Department of Public Health and the city attorney, all of them, to inform the noise ordinance task force what their sunshine responsibilities were. And it seems to me that the fact that they did not is, to me, inexcusable. So that is the reasoning behind my motion.
Okay, is there any further discussion from members of the task force?
Excuse me, may we have some
Yes,
comments?
yes, I was going to ask for
There's been a
public
motion and a
comment.
second, right?
Right, I
So
was
then
going to ask
it's-
for public
It's
comment.
time for public, thank you. First, let me thank Ms. Gamas for educating me that there is a noise ordinance task force in the city since 2008. This committee, this task force, has been meeting in camera without any public participation. And I thank her for bringing it to my attention as well as the Sunshine Ordinance Task Force. Secondly, you know, it's very frustrating to hear you relitigating issues that have already been decided by the full task force. You have an order of determination in front of you today, and this compliance committee's duty, only duty, is to ascertain if there's been compliance. You need to read your orders of determination before you start the proceedings. When you do that, you know, it's a simple, did you comply or did you not comply? Secondly, your order of determination was against two individuals, Mr. Rivard as well as Mr. Bhatia. Mr. Rivard is not even here today. That troubles me, because one of your orders of determination was against a person who's not even here. So perhaps you may want to consider referring him to the full task force for failure to appear. And finally, let me say this. There's clearly been no compliance either with the public meetings laws that are mandated by the Sunshine Ordinance Task Force or the public records requirements of the Sunshine Ordinance Task Force. You know, do what you may about serious and willful violation or not, but once again, the Department of Public Health is just blowing you off in your orders of determination. They may be ambiguous, but it's clear what they were compelled to do by the full task force. That is, produce the records that were requested by Ms. Gammons and open up the proceedings in the public meetings. The agenda for their September meeting does not list public comment on their agenda. There is no way to find out any minutes of the Noise Ordinance Task Force the past few years, because it probably hasn't been any. This task force is comprised of city departments, and they're doing business, making public policy at the exclusion of the public. You should not accept that. Thank you.
Thank you. And for the record, is there any further public comment?
We're not allowed
Okay,
to
so,
speak.
no. So seeing the matters back with the task force.
Call the question.
Mr. Rustin, would you call the roll, please?
Yes, Madam Chair, on the motion, Member Snyder?
Aye.
Snyder, I Member Nee.
Aye.
Nee, I Member Wolf.
Aye.
Wolf, I Member Johnson.
Aye.
Johnson, I Member Washburn.
Aye.
Washburn, aye. Madam Chair, there are 5 ayes, the motion passes.
Just a point of information. Was this motion to include that letters be written to all the entities stated by the maker?
No, the motion was to recommend to the full task force
Okay,
the letters go to those various entities,
okay.
or a letter goes to those various entities.
Very good, thank you.
Are you with your the second motion?
I have some thoughts about remedies. We're saying that we're recommending to the full task force that anything that the noise ordinance task force has done is null and void. They're going to go out of existence in a month. They have another meeting scheduled. Do we want to speak to what we want them to do with the remaining time left?
It's not with certainty that they will go out of existence. They can request to the Board of Supervisors, and in fact, I think it's on in their minutes of the last meeting that they are going to discuss whether or not they want to make a request to the Board of Supervisors to extend their sunset date.
I'm just wondering if we think that our task force has a role to play in helping to ensure that going forward there's opportunity for the public to be fully engaged in the work of this task force. In other words, that there's some remedies, something productive that could be done going forward. That's what I'm asking. Member Nate.
Well, I believe the Noise Ordinance Task Force and the DPH representative have already told us that, having become aware of what their requirements are, they are perfectly happy to abide by them. And so I think, we can take them at their word. However, if it turns out that there are open meeting violations going forward, then again, if somebody comes to us with a complaint, we can very quickly find them in willful violation and refer the matter to the Ethics Commission as well as to the Board of Supervisors.
Well, I think we had talked at one point about referring this matter to our Education and Outreach and Training Committee to work with them to say, this is what we recommend to you. I think they've indicated some desire for help, given how badly this is, I also, a concern, I want to just get this on the record once again, a concern I raised at the full task force meeting is this an isolated incident of this type of thing happening, or are there other task forces running, rogue in the city? Do we have a bunch of rogue task forces? Given that the Board of Supervisors kind of dropped the ball on this one, what's going on here? I think it's a very important issue for the city, and I don't know if we could have a role in saying, hey, public, this is what's going on.
As far as any other investigation, I think that would, we would do that separately from this particular issue. I think it's a good question. We don't know. This is a very interesting case that it appeared, out in the open. But with reference to the second motion, I think we do have to find some violation and make some recommendation. And the reason why is because there was no representative from DPH that showed up that could answer any of the questions regarding the documents that Ms. Gamez was referring to at the hearing. Mr. Rivard was clearly not capable of answering any of those questions. He was only able to answer questions in relation to the task force and any of the work that he had done, but not to any of the information that Ms. Gamez had asked anybody at DPH or yourself, Dr. Bhatia. So, at the hearing, the task force did find in violation for that. Now, compliance That's what we're here for, compliance of that. Has compliance been made for that? I don't know. I don't know that Ms. Gamez has received any further documentation since the hearing, and if that satisfies anything or not. I'm not clear that has happened at this point. So I'm going to leave that open for a little further discussion so that a motion could either be formulated or not.
Member Johnson.
If I may, I hear what you're saying, but I think that I really appreciate Member Nee's suggestion about asking for compliance because the order is not black letter law clear. So I'm reluctant to find some kind of a willful violation that we forward it on. I'm a little bit disappointed that, I think all of the department heads have to sign a document saying they know about the sunshine ordinance. So it's frustrating for us to have to, pull the documents out like pulling teeth. It's frustrating to hear you say we don't have to keep our emails there's a state law I can cite to you that requires people to keep reasonable documents. And so that concerns me that, to hear those kinds of things is a concern. But I would like the compliance to consider what Member Nee said because, we can say this is what we expect. The documents are put in there. Whether we state it in here or not, they're disclosable. It's not the kind of thing like the court didn't order it, so we don't have to turn them over. The sunshine law requires, they've been due the whole time. They were due to her before she ever came here. So I don't want it to necessarily be open to interpretation that the Sunshine Ordinance Task Force doesn't tell you have to do it, because we want to limit complaints. We hope to, the education and outreach training, we would hope that we don't have to have the complaints. So this, like the noise ordinance, is the guide. We shouldn't have to necessarily say it. So, but finding willful violation, although if by appearances we could do that, because the order of determination didn't have that black letter statement in there, I feel that there may be some due process issue that comes up with the enforcement agency that we send it to. That would be the same. But at the same time, I don't think that it just goes away because I didn't write down something that was due way before she got here. And that was just a point of speaking to Member Wolf's discussion about the violation, the Wolf violation.
Member Wolf.
Then, based upon that, I'm wondering if a motion would be in order to provide DPH the opportunity to produce the documents that they now know that are public and disclosable, and as requested by the complainant, and that this be revisited at the next full task force meeting for compliance.
That's even longer than 5 days. That's a longer time period than
It's 2 weeks.
Member Snyder.
I could take a shot at a motion to that effect. See what you think.
Chris, could you tell me when's the next full task force meeting?
26th, I believe.
23rd.
August 23rd.
2 weeks from today.
Yeah.
So I move to declare that DPH must produce the requested documents before the next task force meeting on August 23rd, and to recommend that the task force make a determination at that time whether DPH, let me start over again, sorry. So I move to declare that DPH must produce documents requested at the next task force meeting on August 23rd and appear at that meeting, and to recommend that the task force make a determination at that time whether DPH has complied, and if not, whether further referral to the Ethics Commission is warranted.
Second.
I'd like to make a friendly amendment if I could, because I'm observing the respondent shrugging and wondering what he's supposed to produce. So I would include in our recommendation that we urge the department to work with the complainant to identify what it is the complainant wants. I mean, that is, you know, there's time to do that. That's reasonable. That will help, possibly help the complainant get the documents that she wants. So I think that should be it's part of the law, so we can, that's.
Second accepts.
Yeah. So should I take a crack at rewording that?
Go right ahead.
So the motion is to declare that DPHS must confer with the complainant to determine what documents are requested, and then to produce the requested documents before the next task force meeting, and from there it would continue on as the motion was already. So they're just ordering them to get together to work together to determine what it is that's being asked for and what should be produced.
If I may just, if you can get the audio tape up as soon as possible, because we just went through an hour and 2 hours of the things that we thought were producible. You know, the things that we thought you could search, we just had a really long discussion about it. So some of that is in that discussion. For example, the communications that we were trying to discuss that might be specific to implementation of that of the ordinance, or with employees, supervision employees, that whole discussion was about. So if you could put that up there.
Do we have public comment on the motion?
Yes, thank you. Is the tape running now?
It is.
Okay. I'm going to oppose the motion. You know, the 5-day black letter law, as you say, is superfluous. Compliance is in the Sunshine Ordinance, and Mr. Bhatia is well aware, or he could get advice from legal counsel as to how many days he has to respond. Again, I'll make this other point. Your order of determination was also against Mr. Rivard. In this motion, does not advise Mr. Rivard of anything. You got an order of determination against Mr. Rivard for violating public meetings as well as public records. Mr. Rivard is not here today, and your motion does not compel him to do anything else in the future. So with that said, I'm going to oppose your motion. You have an order of determination. It's in front of you. Both Mr. Bhatia and Mr. Rivard have not complied. And again, I'll state this. Their compliance with public meetings, their agenda for September, there is no item on the agenda for public comment. So again, I'll oppose your motion. Thank you.
Thank you. Is there any other public comment on this motion? Seeing none, then that is back with the task force. Anything further?
I would agree to, if there was friendly amendment could be made to include Mr. Rivard in that too, because he also is party to the investigation that the Dr. Bhatia or Department of Health may not even have record for.
Yeah.
So I would add him
So it would be that the DP, that Tom Rivard and DPH must meet?
Well, you have to name people. So here you have Dr. Bhatia, who's representing DPH, and then you have Mr. Rivard, who's representing the Noise Ordinance Task Force.
But I mean, what we're ordering is that they somebody with DPH get together with.
I understand, but the information that DPH may have may not be contained in the task, may be contained in the task force and not in the DPH. You know, you never know how people keep files. And so you never know what people have on their desk or in their email or what have you. So,
How about, I understand,
Well, then, wouldn't just adding the noise ordinance task force to it as
yeah,
well?
we could just say that the Noise Ordinance Task Force and DPH.
You would
The
name
thing
them
is, we're
people.
not,
you got to name the people.
but we don't if we're not finding a willful violation here, so there's nobody to, I mean, so
The ordinance, the Sunshine Ordinance does not speak to departments. It only speaks to people. It speaks to public officials, the mayor, board of supervisors, department heads, and all employees. Doesn't speak to about a department needs to do this.
Okay, so I guess we should change it to declare that
Well, the whole DPH though has to be included in it. It's not just one person's documents. Is that what you're saying?
The custodian is the one who's responsible, so
Okay.
you have to name the custodian. That's been the problem with a lot, in past years, that we have named departments or agencies, and then it gets sent to the Ethics Commission, and they
Right,
can't
but
make.
that's not what we're doing.
I understand, but I'm saying that has been the problem here.
Okay,
So,
so let's name, so the motion will be to declare that Dr. Bhatia and Mr. Rivard have to
right,
confer and then produce.
right. And then they can determine whoever in their staff needs
Or
to
they
work with
represent,
them.
right, that's fine. fine.
It's their responsibility to make it happen, that's all.
Second accepts.
Did you get that?
Okay.
Do you need public comment on?
Yeah.
Okay, public comment on the amended motion?
Oh, I concur fully.
All right.
Thank you.
Now, call question.
Mr. Weston, would you call the roll, please?
Yes, Madam Chair, on the motion, member Snyder?
Aye.
Snyder, aye. Member Lee?
Aye.
Lee, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 5 ayes, the motion passes.
Thank you. At this time, I'd like to call for general public comment for items not on the agenda.
For items not on the.
Not on
Could
the
I
agenda.
say one thing before you
Member Snyder?
go there? Dr. Bhatia, I just wanted to say, what we've done here is really, procedurally, this is very unusual, and we basically handed you a golden opportunity, I think, to comply with the public records laws. And I see you shrugging as if you don't know what it is you're supposed to produce, but that's the thing. When an agency gets a request from a member of the public, it's your job to look at the ordinance and say, what is it that we have to produce? What is she asking for? And then to find the answer that complies with both of those, the request and what the law is required. So if you have questions about what it is that you're required under the law to produce, we have a good government guide. There are ample resources to determine what you need to produce if she asks for example, communications. And we've already determined that in the first instance you didn't comply. DPH did not comply. And so now it's a golden opportunity to do it. And,
If you're, again, I'm willing to comply, and it's not that I'm saying, I don't know, I really, honestly, I think that I've spent an hour educating you about the noise ordinance and our procedures. You know who communicates with what, you know how we do it. I think you have also an obligation to tell me exactly, I don't know if you've looked at her request in writing. I don't know if you've looked at the 100 pages of documents we've given her, the 100 plus pages of documents we've given her, and said exactly what you think we're missing. We are trying.
We just did.
Your brain. There was some brainstorming. There's some brainstorming here, and again, I am and I will take your brainstorming to
But
heart.
there is one thing. When you come before us the next time, when we ask you, do these exist, if you say, I don't know, well, no, you didn't. because you're gonna be representing that
No.
you know certain.
Next time what I will do,
That's-
next time I'm a scientist too, next time what I'll do is I'll tell you my methodology. My PIO conferred with her. This is how she narrowed the request. This is exactly what we did to search for the documents. I will give you the methodology and what they produced.
Then we'll know for sure that
But we did that.
Can
We
I-
did that, and you're taking a request, and I think you're broadening it, and in a very ambiguous way that's very hard for someone to interpret and interpret.
May I please?
Oh, you
There
started.
were
There was an
specific-
extra communication that you started.
There
I think
were,
that
there
is-
are specific,
No,
I have,
don't- please.
this is the response I've
No,
gotten all along.
no. I mean, we.
I have in my, specifically, there are, for example, in a noise survey, there's a reference to a letter sent to Grub. I've asked for that specific document. It hasn't been. There are items, specific hard items I have pointed to and never received. The 100 pages that you've sent me, 85 of them were my own emails to and from. There is
If you
very
send me a
little.
specific list of items, I'm very happy to provide them.
Excuse me, I believe that, I'm not discounting what you say, but I believe that at this point, it's best, the two of you are heading back and forth here, that it's really best done outside the meeting.
Our PIO will speak. Okay?
PIO.
Is this,
Public
Public information.
am I required?
No.
Thank you both for coming.
Thank you, Beth. Okay, now's an opportunity for public comment for matters not on the agenda.
Yeah, I have a question regarding, so Dr. Bhatia and Mr. Rivard, as examples, are required to comply. I have gotten every indication today that he has not.
it's on the agenda.
Okay, you're
Yeah.
discussing,
So, but the
you're
point-
discussing an
I'm
agenda item.
being referred to a PIO who is completely ignorant of the material
Again,
here.
this is,
Well, I mean, but this is also a general procedure, like, what is it that the PIO has not been named, I think her name is Eileen, to act. So what, I guess.
That will come out at the task force meeting.
right.
The
So-
results of what has happened today you will show up, they will show up, and then we'll find out if they have complied with everything that you are requesting.
We just can't discuss it because
He's off the room.
Reese
Yes,
has
right.
already-
It's done.
It's not.
Sure, but in general, a PIO's responsibility vis-à-vis the principals, the directors, the department heads, what is that relationship to the public when the public goes and asks a question?
That will be determined by the task force as to whether that person is knowledgeable enough or whether that person is the custodian. And that's really much more that we can say about it right now.
I mean, as a general matter, the head of an agency can delegate the responsibility of looking for the records and figuring out what needs to be found to somebody else. I mean, they don't have to personally go to the requester and say, what is it you want? Okay, I'll go look for it.
Also, Ms. Gimmons, I want to say that we have a full-time staff person and Chris Rustin who can work with you too in the upcoming days. So, but we need to move on. Our item now on the agenda is public comment.
But among the things I can request are a line item of everything that they, for example, communications with an attorney that they are excluding for one reason, but I can request a log. I mean, that's how it happens in law. If there are things that are being withheld, you produce a log and you say withheld pursuant to blah, blah, blah.
Let me just make it really easy. You filed the original complaint. You asked for certain things. You didn't get them. Now's your opportunity to go confer with them for the next 2 weeks and find out and get those items.
Make a list.
With the list. And then when you come back to the task force in 2 weeks, then you make a report. And you'll have an opportunity and they will have an opportunity. And then the task force will determine whether they complied.
And I'll just, is the
We
next,
have to stop
We
discussing.
really,
Yeah.
we do. We
but
have-
just regarding the agenda, it says next scheduled meeting September 13 is of this body?
Correct.
Of this body.
So it's not the.
Full task force,
It's meeting in 2
August
weeks.
23rd.
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 23rd, 2 weeks from today, and then normally this would be 2 weeks after that, but because of Labor Day, it's the 13th, is that?
It's the
okay?
second Tuesday.
Second Tuesday.
Second Tuesday.
Right.
Okay, thank you.
Public comment.
I'm done, thank you very much. Thank you for your patience.
Let's see. Yeah, I want to go back to what the role of this
Can you speak
committee.
up?
Oh, sorry. This one? I just want to comment on the role of this committee, and I think what you go beyond the duties of what your responsibilities are at this committee. You tend to relitigate these cases, and it doesn't do Ms. Gamez any good to get the record she's seeking, or get the task force, the Noise Ordinance Task Force, open up to the public. You've already made your determinations, and this committee should be solely focused on whether there's been compliance. And you tend to veer off in issues that have already been addressed. And I don't think that's the preference of where this committee should be handled. Secondly, let me say that I am troubled, though, about the orders of determination if they're defective. Perhaps when you issue an order of determination, they should go out to all task force members so that all the task force members, one of them or more, can see that there's a defect and correct that defect before it goes out, so that getting the records or getting the ability to speak on noise in the city would go forth if your orders of determination were enforced. Thank you.
Thank you. Mr. Rustin, could you call the next item on the agenda?
Yes, Madam Chair, the next item is next steps on Ethics Commission proposed policy for handling sunshine-related complaints.
Ms. Gamma's consider applying for the task force, ours.
Thank you for the invitation.
serious.
I am a commissioner. And by the way, my appropriate title is also doctor. I'm a PhD, but I don't normally do that, or whatever. I'm a lawyer now,
What commission?
I'm on the status appointment. I was appointed by
Oh,
committee.
okay.
And so it was in that training that I discovered all of this, and I have to
Well, we're
say.
disappointed that we wouldn't have your. We are.
You can request my being transferred. But thank you very much for.
Well, the city does have a whistleblower program. Read your grand jury.
Let's not go into that.
See how effective. Yeah. Oh, I'm sorry.
Interesting.
Yeah.
I'll Google it.
Okay.
Ciao.
Best wishes.
Thank you.
Sorry.
Madam Chair, just a point of information, the agenda states that there's an attachment for number 5.
There's no attachments, Madam Chair.
I went to the Ethics Commission last night, and if you are interested, I can briefly report on what was said there.
Let's just have any sort of status report that there is. I'm anxious that we
One
move forward with this.
One thing I would like to say that I think is I'm really proud of the task force, and that's that, this was the Ethics Commission, one of the things that it discussed was how to respond to the grand jury report. And I know that it appeared that in their response, their draft response, originally it had said that one of the findings was that they didn't have hearings on 18 of 19 of our referrals. And so one of the things in their responses was that, well, we sent them regulations over a year ago and they didn't respond to us. And because we were able to really pull it together and send them over on the 1st, they couldn't do that. So now instead, in their response to the civil grand jury, it says the task force has given us our comments and we'll be responding to them. So we weren't able to say that we didn't get it to them. So we got it to them just in time, because then they got to do that. So I think that's really good. And Mr. Grossman and I both made reference to the joint meeting, because one of the things that is disappointing in Mr. St. Croix's executive director report, he did nicely put in that the draft regulations to complaints and referrals, so they got that two separate, had been sent over, and that the staff will review these comments and provide recommendations to the commission at a future meeting. And he didn't mention that, the joint meeting, but we both at public comment suggested that the adversarial relationship would be benefited by, we could eliminate it if we could all talk about it together. So I guess their next, when Mr. Grossman, I know, is very concerned that the staff not tear apart what we did before the commissioners actually have a chance to look at it. So I'm not sure what we can do about that, or if anything.
So, I thought we sent our recommendations and the memo that explained what we did and a cover letter. I thought that went to all the commissioners, all the ethics commissioners.
Mr. St. Croix did represent to us in an email that it was forwarded to the commissioners. But he does say here that staff is going to review them and make their recommendations about what we did to the commissioners. So.
Fine. The question is just whether the commissioners got a copy of our recommendations unabridged by staff.
In my letter to Mr. St. Croix, I asked that he send it to the commissioners, and he responded it had been sent to the commissioners, but that it wouldn't be on the agenda for this meeting. So
then
you'd have to inquire of him. We could inquire of him if it went, fully as it was before it was reviewed.
On a peer-to-peer level, I would suggest the chair
Okay.
to contact the chair of the commission, of the ethics commission.
We cannot contact, we have to go through St. Croix.
No, that's incorrect.
I thought
You
we
can
did
contact,
email.
absolutely can contact.
Through the chair, we do not have the commissioner's email, right? A little digging could bring it up.
This is city business. We can get contact. That information absolutely is public information. It's on their Form 700. It's on many documents.
I think that they can rely on their staff to email them. I don't think they have to turn over their personal email.
You have to have a way to be able to contact. The mayor has a contact, supervisors have a
Yeah, but you
contact.
can't contact the mayor on his personal email. Your only option is to contact them on that. Like, we don't have to give our personal email to the public.
But we're not.
He can send it to us.
But Madam Chair, we are not the public as sitting members of the Sunshine Task Force. We are public officials, and public officials doing the business of the city have absolute connectivity with other members of the city family. That's the prerogative and privilege of being a public official.
I hear what you're saying, but I think that the formula for that is that we go through their staff the same way that they go through, on the Sunshine Ordinance list. I mean, I'm certainly happy to attempt it. I mean, Mr. Kerr is the chair, right? He's an attorney, and I'm certainly not reluctant to do it. I'm just giving you the fair, true reality that I've seen and sending over. I don't know, member Nee has had interactions with the Ethics Commission. Maybe you could, have you gone through Mr. St. Croix?
At all times, yes.
I personally have requested several people who used my email, my personal email, that I became chair, to go through Mr. Rustin because I wanted it to be a public record. And that puts a light on their decision to say it. Obviously I can always send it to him, and I didn't start out that way. It was after they had taken advantage of doing that. So I'm not saying I wanted to try to do it.
I'm wondering.
I think you're misunderstanding what I'm saying.
No, that it's not I'm not just a random
Yeah, it has nothing to do with the public. It
But
is,
he's not required to give his email to me.
I have a suggestion.
Sorry.
I think what we're trying, I think the strategy we've talked about doing in the past, and I think, what we need to do now, is to schedule a meeting between our committee and this ethics commissioners before their next meeting, if we could possibly do that. That would, within the next, say, 3 weeks, that would sort of, in effect, do an end run around St. Croix's, digesting and slicing and dicing our recommendations, and for them, we would have an opportunity to meet, as peers before that.
Through the chair, to Mr. Picarello.
Mr.
It was my impression that the commissioners were somewhat dependent upon the staff, that they don't act so much independently. I wondered if you had that same.
No, I got the impression from the Ethics Commission last night that they were very receptive to having a joint meeting. The vice chair actually said it's been 2 years since you've had a joint meeting, and it's time long overdue that the task force and the Ethics Commission should have a joint meeting. So, I like your suggestion of having a meeting in the next 2 to 3 weeks prior to the Ethics Commission meeting on the regular agenda, because at that time, I believe they will then discuss your proposals that you submitted. And I agree with you. It would be helpful for the task force to talk to the ethics commissioners in a joint meeting without the interference of Mr. St. Croix.
Right. This is what we've talked about doing. I think it's.
Mr. Grossman says that he doesn't think the commissioners would do it without their staff's issues in hand. But that doesn't mean that.
Well, let's try.
I'm
Let's
just
try.
putting it all out there.
in the past, when we've had joint meetings, both, at that time it was Frank Darby, who was our administrator, and Mr. St. Croix were in attendance. Okay, they did not sit at the table with the rest of us, the discussion, and they were not part of the discussion at all. They were only there to make sure documents, or if we had any specific questions about the administration of either of our bodies. But the discussion was specifically between the two sets of commissioners. And just in my own personal, when Eileen Hansen was on the Ethics Commission, even though she was a friend of mine, when I wanted to contact her on as a commissioner level, I would send a notice or an email to somebody on staff saying, "Can you please have her contact me? Here's my contact information," and she did. So that's a channel the way to me a good protocol of doing it, and it doesn't. I don't think that there would be any abridgment of that they would not pass that information.
Member Nate.
Yeah, my recollection of the meetings differ a little bit from Member Wolf's. Yours may be perfectly accurate, but my recollection is that Mr. St. Croix did in fact sit at the table with the Ethics Commission, and that he at times did weigh in. That's my recollection. Maybe Mr. Rustin can provide some. You weren't with us then, were you?
Was that the one in room, through the chair, was that in room 400?
I think so. We were sitting up high, and they were sitting, and both Mr. St. Croix and I think it was Frank Darby. Was it Frank or
It
you?
was me.
They were sitting below.
No, it was, I think,
I chaired this committee at the time.
yes, I think Mr. St. Croix was up there.
Was he up
Yes.
there? I didn't remember.
And I believe that at times he did.
Because Richard Moore was down there
Oh,
with the recording, doing the recordings and.
okay. Well, I would respectfully, during those meetings in the future, have staff not sit at the same dais level as the commissioners. The discussion needs to be between the commissioners.
Do you want the request to come from the chair? Do you want the request to come from the compliance and amendments committee?
Well, who's going to be meeting with them?
Compliance and amendments.
And I would ask the chair to make sure that staff do not sit at the same level.
No, I mean the request for the meeting.
Oh, yeah,
Come from me.
yeah.
Okay.
You can follow up on it. You can say.
At the
my letter,
request
you can
of,
follow up on my letter. Did you get a copy? Did
Yeah.
you get a copy? So you could follow up and say, you know, I'm hoping to schedule for your next.
Mhm.
There.
Right. Sign.
And attach a copy of our suggestions.
Mhm.
Although, this is on tape, and I know it's adversarial. I carefully called them recommendations, I carefully called them ours, you know, well, I think I used a phrase, recommended edits. And if you notice, Mr. St. Croix referred to them as comments. So I would be really careful not to choose strong, peer-oriented words. That's
Well,
what I did.
yeah, I'll follow, it'll be a follow-up of your letter, okay? So this would be, give them a range of time, say, between 2.5 to 3 weeks from now. 2.5 to 3.5 weeks.
I will be out of town from the 21st to the 29th. And then you have Labor Day, which is the next long weekend.
Mhm.
What if they'll cancel their meeting, because it's on the second Monday? The second Monday, maybe not quite.
Oh, okay. I'll get that too, and together and run it past you tomorrow, and everybody. All right, anything further? Public comment on this item?
I was just going to suggest that, if it's not convenient for all 5 members of the Ethics Commission to meet jointly, perhaps the chair and the vice chair would suffice, just to begin the discussions of the issues. Because this is a work in progress. There's no consensus. We all know that. So if, 5 members cannot meet jointly, then, maybe the chair and the vice chair would work just to begin the discussions. And then the Ethics Commission could, when they meet next month, they can discuss what was discussed jointly between this task force and the chair and the vice chair. Secondly, let me just say this: I don't see any purpose in excluding staff. Mr. St. Croix is a reality, and to exclude him from a joint meeting is not going to be productive. I believe, you want Mr. St. Croix there. You want to hear his positions, because you're naive to believe that he doesn't have a large influence over the commission. It's a fact. He has a lot of influence over the commission. So I think you want him at the meeting. You don't want to exclude Mr. St. Croix. Thank you.
Thank you. Member Nate?
A couple of things. First of all, Member Wolf was not suggesting that staff be excluded. What he was saying is they shouldn't be at the same table. At our level of table, they should be seated, where staff would ordinarily be seated. That's the first thing. Second, with respect to a discussion involving only the ethics chair and vice chair, it's a five-member commission, and the, they could not have any real substantive discussions or take any kind of vote if there were only two of their members present.
Well, would there be actionable items in this joint?
Maybe not.
But I appreciate what you're saying. I would just like to see this process unfold, and the communications between the task force and the ethics commission is to the benefit of people seeking records and participating in open meetings. So I'm looking forward to it.
Member
Yeah, so I agree with Member Nee. It'd be good to get a quorum of the commission to show up, because if they hear what we have to say at that particular time and think that it's a good idea and they need to do that, separate from what they may be hearing from Mr. St. Croix, who would be sitting there listening to all of this, but not party to the conversation. That's really the key thing for us here, is kind of removing the gatekeeper and having the conversation with the decision makers. And so I'm very much more interested in that, and that if they want to make a decision and they're here and they've scheduled the meeting as being an official actionable meeting, then they can take action at the time. I'm game for that. We can move them, if we can convince them and move them to do stuff, let's do that.
You're just more optimistic than I am, that's all.
Yeah, I am. I'm being very optimistic. Maybe naive.
Well, that's the way to go. That's the way to go into that meeting, I think. To be optimistic, believe in what we're proposing.
We've got nothing to lose, because we're already there.
Okay. Members, anything further on that item?
No.
Okay. Mr. Weston, would you read the next item, please?
The next item is the administrator's report. I have nothing new to add. Sorry, go ahead.
I was going to commend the administrator for getting a draft agenda to Mr. Street early so that he could get his instructional letters out to us with the pack. That's part of what you're doing, so I thought it would be their report.
Is there any public comment on the administrator's report?
Just, when I click on the administrator's report, his charts are going the wrong direction. And maybe I don't understand the computer, but I can't get his chart to read, I guess, horizontally. In other words, what he puts online is going this way. And I can't read it unless I turn this way on my monitor.
You need to rotate. It needs to be rotated. It's in
I
landscape.
understand.
It's in landscape.
No, I understand it needs to be rotated. I can't rotate what he's putting online.
Oh, really?
Yeah.
Not a PDF.
Is it a PDF?
I think
So then you should be able to rotate it.
I think you right-click it, and then there's something that appears on the menu when you right-click a PDF that allows you to rotate. I think that's how you rotate a PDF.
My point is, how hard can it be to put it,
Yeah.
well, one can read it on the monitor without
I'll
navigating
I'll-
on my monitor.
I'll look at it.
To read the items.
Okay.
And perhaps maybe a little more history on the history of these cases. It's pretty scant information about when the complaint was filed and the determination. I'd like to see a little more history and perhaps maybe even written narrative. Most administrative reports I've seen from other task forces, commissions, there's a narrative report from the administrator, and I'd like to perhaps see that from your staff.
Thank you.
Thank you.
Mr. Weston, the next item on the agenda?
The next item, Madam Chair, is announcements, questions, and future agenda items from committee members.
Member Nee?
Yeah, I expect to be out of town approximately September 10th through September 14th, which means I will miss the next meeting of this committee. And this will be on family business.
Mr. Weston?
Madam Chair, could I ask Member Well, you're going to be out of town from the 21st too?
To the 29th.
29. Thank you.
Okay, there are no further items?
I would ask that the chair of this committee maybe have a discussion item on the agenda before any action items, just to discuss what the scope of the committee should be doing. I mean, I've heard not only member of the public, Piccirillo, but various other members state that the Compliance and Amendments Committee is going way beyond the bounds of what they need to discuss. You know, I have a certain perspective of for the interest of the complainant, and some of those opinions kind of float with my interest in asking certain questions, and I think it's worth a discussion among us, because I do get personally, I get complaints and opinions from other people about how and why I make those questions, and I don't feel like I'm relitigating it. So I want to at least address it and have a discussion among us about the scope of and whether, you know, those things should be shortened. Because if they are, then it's just a matter of, again, as some members have said, was this done or wasn't this done, and just make a decision about whether it was or wasn't done. And I think there's more to this committee than there is to just that.
Yeah, I agree. I think the one thing that I've noticed is that I think the parties are often confused about why they're here too.
Right.
And I've thought about how do we fix that or improve that, and maybe, I don't know, I mean, maybe some wording in the order of determination saying that what you're going to do with telling them why you need to show up at the Compliance Amendments Committee, what we're going to expect.
Pro forma paragraph or something.
Yeah, like a paragraph saying the Compliance Amendments Committee's job is to determine whether there's been compliance with the order to produce or with whatever, I don't know, with the order to produce records or whatever in 5 days. Please, you know, come prepared to discuss this. Because they're often here and they're kind of, I can just see it in their eyes, they're floating like, what are we supposed to be doing here? And I think the same confusion bleeds over into us, and I'm not excluding myself from this at all. We end up, it's hard not to relitigate because in order to determine whether there's been compliance, you have to ask factual questions about, well, what did you produce? Mm-hmm. Since the last time we checked in, you were supposed to have produced A, B, C, D, E, and F. Did you? And you have to ask. You have to determine whether there's been some further
production. And if they didn't, then there's a further continuing
but that inquiry very frequently, I agree with Mr. Piccirillo's, very frequently, and I did it tonight, bleeds into larger questions about what they produced earlier. And it's hard not to do that because it's hard to remind yourself while you're on a line of questioning that we're only here to determine since the last task force meeting what did they produce or not produce. So that would be just a topic to discuss.
Okay, so Mr. Rustin, if you could make a note for our agenda next time.
Okay, may I make a suggestion? Could that be part of the notice I send out to the complainants and respondents, reminding them of the meeting?
Saying what you're supposed
Yes,
to do.
why they need
Yeah, absolutely.
Yeah, the order determination and then the reminder, that'd be perfect, yeah.
And it may be good at the beginning of the meeting for the chair to repeat that.
Reiterate that.
Remember,
yeah.
what we're here for is to blah, 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 and so what's...
Yeah. So it's really,
Everybody remember that, you and us and all of
Right.
us.